Assalamualaikum warahmatullahi wabarakatuh. To our beloved lecturer, Sir Muhammad Izzuan Abdul Manaf. We are from Group 2. We present about the differentiate to power of the Director General of Trade Union, Dgtu, from Director General of Industrial Relations, Dgir. But first, let me introduce our team member.
Assalamualaikum warahmatullahi wabarakatuh. I am Yusufizah bin Ridwan. I present the introduction and the Director General of the Department of Trade Union, Dgtu. First of all, we go to the scholar definition. According to Dgir 1998, industrial relation is the connection between employers, workers, and trade unions. Secondly, the main area in industrial relation, it is divided by law, which is employer-union relation, employment law, disciplinary procedure, and contract termination. Besides, the responsible Ministry of Human Resources, enforcing labor law, industrial relation manager, and trade union government. Both departments have different objectives. The Malaysia Department of Industrial Relations improve employee relation. The Department of Trade Union Affairs guarantee trade unions generate pleasurable, skill, and disciplined work that help the country achieve its social and academic goals. Next, Trade Union Act 1959. West Malaysian, Sarawak, or Sabah employees form a trade union. Workers can only join their professional union member industrial, social, and intellectual progress are supported. This union was created to analyze member problems such as wages and working conditions, and to push for pro-worker law and policy. Last but not least, the type of unions. It is divided by three, which is public sector workers unions, private sector employees union, and private sector employer unions. Next, we go to the Director General of the Department of Trade Union, Dgtu. The Yang di-Pertuan Agong was instrumental in the appointment of the Director General of Trade Union. Next, the selection of the Dgtu. To be the Dgtu, the official must have intensive authority and be qualified to govern Malaysian trade union. Furthermore, the 1959 Trade Union Act allowed the YDPA to appoint Deputy Director General, Assistant Director, Trade Union Director, Trade Union Personnel, and other officers. In addition, the Malaysian federal government has set and enforced the ethical standards and control their actions. As part of the government infrastructure, public officials execute policies and decisions. To achieve these ideals, they must offer effective, efficient, transparent, high-quality, compassionate service. Lastly, the Ministry of Human Resources is in charge of overseeing the Department of Trade Union operation. For example, consider trade union, skill development, industrial court, and labor law.
Next, I will continue the power of Director General of Department of Trade Union. Firstly, the Director General of Trade Union Affairs in Malaysia invested with considerable jurisdictions over registration and deregistration of trade union. Section 4A of the Trade Union Act 1959, the authority's responsibilities and future impacted on the Director General by this Act and any regulatory requirement. The Director General shall have and may exercise all power, discharge all duties, and perform all functions necessary for giving effect to and carrying out the provisions of this Act. Secondly, the responsible of Dgtu. It is divided by two, which is to register trade union and to remove the registration. To register trade union, Dgtu can register a union as needed and refuse to register a trade union in favor of specific emergence, trade inventions, or setbacks. To remove the registration, refer to the Dgtu can reject a trade union registration certificate under Malaysia Trade Union Act 1959. This invalidate the union. A trade union make two requests when two or more unions are registered in the same trade, occupation, industry, or place of employment. The Dgtu may invalidate the certificate of registration of the union with the fewest members and remove it from membership. The Dgtu can dissolve a union branch if it violates the Act or the union rules.
My name is Muhammad Aziz bin Zabjihan and I will present about the Director General Industrial Relations of Malaysia. The Dgir of Malaysia is the head of Industrial Relations Department and also called as Jabatan Perusahaan Malaysia (JPPM) in Malay. All duties and functions of the department are reported to and referred to the Minister of Human Resources through the Secretary General of Ministry. All industrial relations matters in Malaysia are under the control, oversight and general direction of the Dgir. The Dgir is in charge of enforcing all of JPP Malaysia's laws and regulations, including the Industrial Relations Act 1967, Act 177, the Industrial Relations Regulations 2009, and the Code of Conduct for Industrial Harmony. The power of Dgir is that the Dgir has the authority to provide conciliation services in order to resolve or avert industrial action and trade disputes, as well as counsel for reinstatement in situations of dismissal. Conciliation is the process of resolving a disagreement, and there are some abilities that must be possessed when seeking to mediate a disagreement. Conciliation is a form of alternative dispute settlement. This conciliation brings two parties together to discuss a problem in the hopes of reaching an agreement. Since the conciliator lacks the authority to compel the parties to accept any particular decision, he or she only advises them or arrange a meeting. The Dgir has the authority to resolve issues originating from unfair and exploitative treatment by employers and employees. This can be accomplished by safeguarding employee and employer rights in order to prevent employees from being exploited by their employers or vice versa. Employees and employers must have a peaceful dialogue if a conflict arises in the industry or organization. In order to obtain a fair resolution for both parties, this will result in a fair and win-win arrangement between employees and employers, resulting in a healthy partnership. The Dgir is also in charge of resolving recognition and trade issues. Its purpose is to ensure that a business works smoothly and without conflict. Any dispute between employees and employers over non-employment and employment, as well as the terms and conditions of work for such employees, is referred to as a trade dispute. If the union is unable to resolve the disagreement, they will report it to the Dgir. Then Dgir and Industrial Department will work together to resolve the trade disputes. Thank you.
Assalamualaikum. My name is Afika binti Muhammad Tajuddin and I will discuss about the power difference between Dgtu and Dgir. The first difference of Dgtu is area of power. The Dgtu has extensive power compared to Dgir and have many areas of power, which are in terms of registration, deregistration, fund and accounts, and last but not least is membership. The Dgtu also have the power to revoke or invalidate the registration. But the Dgtu only can revoke the registration when the certificate was issued by fraud, the constitution of the trade union is against the law, the trade union has been violating Trade Union Act, and last but not least, the trade union has been closed down.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ashla Srimati Islan. My ID number is 2020990695. And I will continue to explain about the power difference for DGRI, which is Director General of Industrial Relations. DGIR have limited area of power as the third party to help solving the dispute, which is recognition dispute and trade dispute. These two disputes are act to give an advice and suggestion to both party, union and employer, until they agree to the solution that DGRI given. This process also called as conciliation method. Any disagreement between the employer and worker or employee that is related to their employment or lack thereof, their term of employment or their working condition, and that result in industrial action is referred to as trade dispute under the Industrial Relations Act of 1967 or Act 177.
The second difference of Dgtu is the approach to deal with the dispute between employer, employee and trade union. The Dgtu resolve the problems or dispute by using their own power. For example, in terms of registration, the Dgtu can refuse to register a trade union and the other party cannot interfere the process of registration. According to Section 8 Trade Union Act, the Dgtu can extend the time of registration from 1 month as to exceed the period of 6 months. For example, if the founder of a trade union is in overseas and cannot return to Malaysia within 1 month, the Dgtu have the right to extend the period of registration. That's all from me. Thank you. And for further explanation, my friend Nur Ashila will continue explain.
For the second power difference, DGIR, they have process to deal the problem or dispute between employer, employee and trade union. There were 3 steps in the process, which is conciliation, reference by DGIR to the industrial court, and arbitration by the industrial court. After that, the process to deal this problem with conciliation, which is the department may choose the time and place for the conciliation, to which both the employer and the employee may be invited to find a solution. Next, the Director General of Industrial Relations must bring the dispute to the industrial court for an award if it cannot be settled through conciliation. And lastly, the arbitration. The Director General of Industrial Relations shall refer the matter to the industrial court for adjudication. All participants to the reference toward the industrial court are obligated by the industrial court decision. That's all for me. Thank you. For the conclusion, both Director General of the Department of Trade and Industrial Relations have different definition and power. They have their own law to solve the problem or dispute between employer, employee and union. The right to engage in economic activity is acknowledged within the framework of Malaysian industrial law. However, it is severely constrained. A trade union is required to abide by all regulations, including the Trade Union Act 1959's rules. Any member who might consider engaging in illegal activity such as strike should be discouraged. Trade union oversee managing union money properly in accordance with union regulation and in compliance with the law. employers or a trade union must receive notice from the union before it can be recognized. And that's all for us from our group to explain about the power difference between the Director General of Department of Trade Union and Director General of Department of Industrial Relations. Thank you.